So, welcome to Protect What You're Building Legal Lessons for Latiné Founders. My name is Taylor Tiemann. I'm going to do a little intro on me. I don't like to go too in depth, but if you want to go on my site and read about me, I would love to meet you. I don't love talking about myself. I'd much rather talk about legal stuff. That's why we're here. But we do have a law firm where we check business owners, creators, influencers, any type of business and or way to make money that you can think of. We protect you as that business. I'm the founder of my firm. We started a little over 6 years ago. I was working in law firms doing civil litigation, and then just wanted to kind of do my own thing. So now we help business owners. I get to pick my clients. It's amazing. And I get to just like be normal, be myself instead of having to like adhere to what our firms wanted us to do. We help, again, business owners, and what we do. The main kind of crux of what we do is entity formation, trademarks, contracts. So I'm going to be definitely talking about all of those things, but any sort of business that you have and whatever legal direction that that business is going in, we can help with as well. But the main kind of themes that we help with are those. Trademarks are kind of my favorite. So I usually kind of lean heavy into those, but I am open to answering any questions. If you guys have questions, please feel free. If you do have questions, I think there's a Q&A session. I will try my best to monitor, but I'm dedicating time at the end to go through. Quick disclaimer, information I share with you today is for informational purposes only. It's not meant to be legal advice. Doesn't mean I don't want to work with you. I just have to give the disclaimer. I'm also California licensed, so anything, if you're outside of California, some of the things we're going to be talking about are specifically state California based, but most of it is just in general. So like federal outside of California. But I always suggest if you have super specific local issues, please talk to a local attorney in your state. If you need help finding somebody, I'm more than happy to help if you want to reach out. Here's today's agenda that I want to quickly give you a broad overview of, and then we'll get into each topic. Kind of just repeating what I said of what we do. I want to touch on each of these topics because they are such recurring themes with every single business that we help, that I think whether you have a business or you are planning to open one or start one, it's just really good to be thinking about these things very early. If you already have a business and these aren't in place, you can always route yourself back, get these things in place. Better late than never. So I do want to talk about entity protection. So how you're protecting yourself and your business from liability, trademark and branding. So owning what you've built, and then also contractual relationships, putting your power in writing. Entity protection. All right. What am I talking about when I say entity protection? Usually the question that we get all the time is, how do I not get sued? Or how do I not get hit with a lawsuit? What do I do if I get sued? All the things we're going to be talking about are ways that you can protect yourself so that if you do get hit with a lawsuit, if there is ever an issue that comes up, you have something to protect you, like a protective shield. I like to call entities like a protective bubble around your business, right? Because they are sometimes able to penetrate within the bubble, but ideally what we want is something that is that like outside wall of protection if something ever comes down, like a lawsuit, a claim against the business, you owe money against the business. So choosing a formal business entity is a conversation that we're having a lot. The most common types of entities or statuses that you can have as a business: sole proprietor, limited liability company or an LLC, and then a corporation. There are some other less common ones in California and in other states. I'm happy to touch on them if you have questions about those. I know that you guys might, I got a heads up, there might be some of you interested in nonprofit stuff. We can definitely go into specifics, but these are kind of our more common entities. And what we're really trying to avoid here is being personally liable for anything that happens either within the business or against the business. Sole proprietorship is our most common. It's not an entity, it's like a status that you have as a business owner and operator. It's our default entity. I keep calling it entity just because they're all called entities, but it's technically not an entity, really. It's a status of your business ownership where you haven't formed an LLC, you haven't formed a corporation, you haven't formed an official entity with your state, but you are still operating, meaning you're still kind of like a thing that the state views as someone they can tax, and somebody that you can file claims against if they want to. They are easy. The reason why a lot of business owners either start this way or remain this way is we find purely because of financial reasons. Like if people had the funds to form business entities, we usually are recommending for them to do so. Even if you talk to a tax professional, if you have a tax pro helping you, they usually at some point are going to tell you to hop into an entity. So sole proprietorship is not bad. There are benefits, there's pros, there's a lot of cons though. So if you do get sued and somebody tries to reach your personal assets, bank accounts, garnish your wages from work, which can be done if you're a sole proprietor and you're doing something outside of your work. That's kind of the bummer of being a sole proprietor is you're not really protecting yourself from that liability of the business. When I say liability, I mean like liable for a lawsuit if something goes wrong, if you're selling a product that goes like wonky and injures somebody, if you're selling a service where somebody takes an action based off of what you've recommended to them and they want to sue you because something got messed up, anything that can go wrong, technically we want to avoid that liability. It is sometimes a little bit more difficult to raise capital because investors don't always love to invest in sole proprietors. Not that it's impossible, they do it. It's just they want to see that there's an entity to protect if there's ever lawsuits. Sometimes they are very invested in seeing that you have specific types of entities like corporations, but we'll talk about that too. The LLC is our most common entity for business owners, just across the board. I think they work great. They legally protect your business. There's no real benefit of having legally no real benefit of having a corporation over an LLC if you're eligible for both and you want the LLC. I think they're cheaper, they're easier to run, they're more flexible. They do the things that you need them to do from a legal standpoint, whereas some people just want that like corporation name, or they have investors where they want a corporation because the investor wants that specific type of ownership. So the ownership conversations, as you can see, a lot of factors involved. The LLCs are usually our go-to, usually what we're recommending, unless of course you have a professional-based service that you're providing, like lawyers, doctors, therapists. In California, you can't form LLCs, you have to form a corporation. In other states, they have professional LLCs instead of regular LLCs. So also take a look at that and see what you're actually eligible for. Easy to create, typically pretty easy to keep up. You have a lot of tax flexibility as well. And they are sometimes easier to raise capital just because investors want to see that you have some form of entity, or like grant programs want to see that you've like invested into the business and you have an entity around it. Again, not impossible, but it's a good thing to have. Corporations, there are several different types. Professional corporations, C corporations are kind of like our general regular corporations. B corporations are for benefit corporations. There's a lot of different types. What they kind of all revolve around are, from a tax standpoint, how you might be getting taxed differently. And then also on the legal side, what it is it's doing. But again, it's protecting your liability. It's helping you avoid, in most cases, personal liability for anything. That's a little different for service providers. If anybody's a service provider, let me know. You still have tax election flexibility. Please talk with your tax pro, your CPA, your accountant, though, when you're having these conversations, because they need to be in the loop. They need to know what you're planning on doing. They need to be able to make accurate predictions and recommendations for you based on what the business is making or planning to make, based on your personal finance situation. It is a very like team effort sort of conversation. Usually what we're doing is consulting a business, giving them our point of view, and then I tell them, go talk to your tax pro. We meet somewhere in the middle and we figure out what it is that you need and want, right? So we can recommend something and you may not want to pay for it yet, or you may not want to pay for it in the next year, totally up to you. Corporations' only real difference in ownership is that you sell stock in your business instead of piece of membership, as with an LLC. Investors typically just want to have corporations set up in the event they want to take it public at some point. If you see your business getting that big, it's a good conversation to have if you see yourself seeking investors either now or in the future. Is like, do I head into a corporation? Can I wait? Corporations do, though, have a lot more regulations placed on them. So you do get a lot more tax benefits, but the IRS has a lot more regulations for you to fulfill. State-wise, you have typically more regulations and things to file on a more regular basis. Cool. That's it for entities. I'm going to head into trademark and branding. I don't know if I can see the Q&A from here. Let me see. Q&A. Okay, I can see it if you guys put stuff in. I don't see any in there. Confirm. Just put an announcement that it's open. Anyways, let's head to trademark and branding. So, owning what you've built. There's a common misconception that when you start a business that you automatically like own everything, right? Like your all your ideas are your own. Anything that you invent is your own. In theory, yes, anything that you create initially, you do have ownership over it, right? Like there's ways that we can try to prove your ownership, but it's sometimes so difficult to be able to show ownership that we want to take it to a level of an actual like state registration for a trademark, a federal registration for a trademark, copyright registration. When we go to register these things, it gives us like a not only a sense of like we're taking this very seriously, but we also get an actual like paper certificate. It's registered with government agencies. There's more recognition of the fact that you own this thing. And so if you ever have to go to court, if you ever have to engage in a dispute about ownership, you have more information and more like ammo to be able to say like, no, I own this thing. I filed this application last year. Like this is mine. I was the first one to use it. All that fun stuff. If you've picked your business name, and or you have a logo or a slogan, that's usually where our trademark conversations are coming in. And you can look at the trademark process. I'm going to talk about mostly trademark, but I'll kind of pepper in some copyright stuff. You can look into these processes before you start a business, when you've just started a business, or even like 5, 10 years in. It's never really like too late if you've never had a problem or a dispute. The benefit of filing these things early is that if somebody beats you to filing, that's gonna create a lot more headache, cause you to spend a lot more money trying to, like, bump them out of the way, or, like, they have maybe secured certain ownership that you can no longer get anymore, which is kind of a bummer. But if you haven't done this yet, and you're looking at it, it's, again, better late than never, and we wanna definitely look at the stuff that you own and if you actually own it. There are 4 different types of intellectual property. That's kind of where we're, like, transitioning into is intellectual property. Trademark and copyright are both a type of intellectual property. Trade secrets and patents are 2 other types of intellectual property I'm not covering just because they don't come up as much. Patent law, we also don't do. Patent law attorneys are very specific to their craft. They take a separate bar exam, which is crazy. What we're usually encountering with business owners is trademark and copyright, but I'm happy to answer any questions if people have questions on those. Trademark versus copyright is a question that we get all the time too of people saying like, I want to copyright my business name or like, I need to file a trademark for this thing I made. People are always confusing them. Don't feel bad if you do. There is some overlap when we're looking at how to protect the things that you've created in your business. But important takeaway is anytime you're creating stuff in your business, like a name, a design, a workbook, a guide, like you are making so many things when you're starting a business and running a business that you have so many different forms of intellectual property, more than you even probably are even aware of, more than you can probably even register at the time, even if we have unlimited funds to be able to register for all this stuff. Just when you're operating a business, intellectual property is such an asset. If you've ever heard about like businesses being acquired or invested in, a conversation that investors are frequently having is like, what's your IP? Like, what are you doing that is so special that only your business can do it? Which sometimes is a certain way that you operate things within your business. Sometimes it's like a specific invention that you've created. Sometimes it's a brand name that everybody's obsessed with and knows. Nobody else can use that. So they're looking at IP a lot, especially if you're looking at getting acquired. Or if you're never going to get acquired and you just want to sell your business down the line, intellectual property is huge. It's like an asset that gets valued whenever somebody's buying a business. Okay, trademark versus copyright. Trademark is what we're going to be talking about. It is, by definition, either a word, logo, or expression, slogan that is identifying the source of your goods or services to your clients or customers. So, how are your clients and customers, anybody that's buying something from you, how do they know it's you that is selling that thing? Common examples, great examples is Nike. The name Nike, the infamous swoosh, the "Just Do It" slogan, we all hear those and automatically know that Nike is whoever is selling that thing. If you see the swoosh on a T-shirt, you know that's a Nike shirt. If you see Nike on a shirt, obviously. If you see "Just Do It" on a shirt, on pants, on anything, you know that Nike's selling that thing. Same thing goes for your business. maybe is not as immediately recognizable yet, but anytime you're using a name, logo, slogan to tell your customer, hey, this is the business that's selling this thing, that's a trademark. Copyright, on the other hand, is a little different area of intellectual property. It's more like things that you're uniquely creating that might not really fit into that like branding conversation, but it's things that you're creating internally that are not like brand immediate when people think of your business, but if it's like a specific, really beautiful design that you're selling on a t-shirt or like an intricate way of how I don't know, you're selling like a guide or like a materials to teach on something, and like you're the first person ever to put that on paper. That's something that could be potentially eligible for copyright protection. It's still intellectual property. It's still extremely valuable. It's just not like branding centered. There's so many different examples with copyright. I put some here, but a lot of business owners are using like so many that I'm happy to answer questions if you guys have questions on that. But there's just so many things that could be protected under copyright. Back to trademark. Benefits of trademark protection. You definitely need to be thinking about this more than you think. This is probably the biggest, like, oh my gosh, moment for business owners that we talk to is like, oh wow, I really should have talked to you like a year ago, or like I should have talked to you before you launched. The reason for that is it's not just a matter of can we go file an application for our business name or our logo because I want to secure it as the legal part. We're also making sure that whatever you're using, it's cleared. Meaning, if you're using something that's already been registered or already been applied for and it's going to create major conflict for you, I might come back and tell you, like, this business name is not a good idea, or like, you might need to change your entire branding suite, which major bummer if you've already invested in somebody to create that for you. So, as you can see, the earlier that we can talk about this, the better, because you don't want to invest time, money, resources, like your whole everything into a name or a logo or a slogan that you can't use moving forward. Um, you actually don't technically legally own names, logos, or slogans until you've registered it. You do have some very limited rights, but you can't broaden or extend those rights at like a federal level necessarily if you don't file a federal application. So if you're a business owner in California or in Texas and you're serving kind of like a local population or even like California, Arizona, Texas, but you want to expand it to a larger, broader federal level, you can't claim ownership in all 50 states unless you actually file an application with the USPTO at the federal level for all 50 states. So if you want to secure the most ownership on paper, getting the application filed is really essential. Definitely a business asset. If you guys have ever seen those like lists of most is it called like popular or like highest ranking brands or like what their value is, they're leaning heavily into what that brand name is, right? Like McDonald's and Burger King essentially are doing kind of the same thing, right? But the McDonald's brand name has a lot more stock in it than Burger King, I would argue. I think a lot of people would argue. So maybe you might like Burger King better. But the name and the branding have a ton of weigh in on if you want to sell the business down the line, if you have created like a major space within the consumer like network and they know your brand, it's definitely a huge business asset. You can also use the registered symbol. It creates deterrence. It's supposed to create deterrence. So there's things that you can do once you have a registration to help prevent counterfeit goods from coming into the US. You can also register it with Amazon. You can deter other people from using your business names, logos, etc. And you have a lot stronger legal arguments. So if you come to me with a dispute, somebody's using your business name, my first question is, do you have a registration? Much easier to show. Sending out a letter, boom, we write it really quickly and we can send that out versus we are now having to dig through ownership documents, first time that you use something like your sales invoice records, and that's creating a lot more legal work essentially for you to have to pay for, which might in turn be more expensive than if you had just filed in the first place. I touched on this a little, but there's levels of trademark protection. There's common law, state, and federal. Federal's our highest. It's our broadest. It's the most ideal if we are eligible for it, because if we can claim ownership in all 50 states, that gives us the most rights. Common law protection is like our default protection. So if you're using a business name and you've never applied to protect anything, you technically have common law protection, but it's typically so limited that it's tough for us to argue if we ever have a dispute issue. And so it's limited mostly in a geographical area. So if you want to be able to say that like, no, I own this business name for all 50 states, but we can only prove you've had customers in California and Arizona, that's going to suck because we can't say like we have ownership in all the other states. State protection is still an option if you're not eligible for federal. They're just different levels. And if you're thinking about like which one you could apply for, which one you're eligible for, those are conversations we can have. Common trademark symbols, I just throw these up here because sometimes they're confusing to people, or you'll see them online, or you see them on websites that you're shopping on. Technically, a TM is used for an unregistered trademark. Sometimes you'll see them on major brand names just because they haven't changed like their logo. They haven't like redesigned it, but they do in fact very likely actually have the R, the registered symbol. The R with the circle is a registered trademark. So that is the only time you can use that is if you have a federally registered trademark. So you can see how valuable that little symbol is once you have the registration, because that is indicating to people, I have this registered at the highest level. SM is for service marks. Not as common. You're probably not going to see that really anywhere. It's just technically a symbol that can be used. Okay, cool. Into contractual relationships. Any questions on trademark? I don't think I see any. Cool, cool. Let's hop into contractual relationships. So, what do I mean by contractual relationships? Really, I'm just want to talk about contracts and how they're important. I know that that's probably something you guys have heard any lawyer say at any point, any area of law, contracts and agreements, having stuff in writing is really important. There are some very limited instances where you don't need a contract. You can technically rely on a verbal agreement. However, they are so limited that I would rather you lean, we have to have this in writing versus let's rely on what we verbally agreed to. Because most of the time, our business contracts with what you need to have them for, we can't rely on we had a verbal agreement. We can't really rely on like, oh, they said something in an email like 3 years ago and I'm going to rely on that. Like it's very difficult to piece together things to create an agreement when if we just had an actual contract that both parties signed, makes it so much easier, so much cheaper for you. I know it's still a headache to get them in place and to follow up with people on them, but if you ever have a dispute, this is like the most annoying thing to deal with as a business owner, and it's usually the most stressful when people are like, "That so and so owes me $5,000. Like, how do I get that back?" Again, my first question is, "Where's your contract? What does your contract say?" If we don't have a contract, then we have to try to piece something together that might work. I can't always guarantee that, and usually we don't have what we need where I can confidently say like, "Yeah, we can demand that money," or like, "Yes, we can file a small claims lawsuit," or "Yes, you can file a lawsuit." Or even if you've created your own contract and you wrote it on your own and I'm reviewing it and I'm looking at it and I'm like, actually, that doesn't say what we need it to say. So, not to like, all that to say, not to scare you, but contracts are really, really important. I know they're sometimes uncomfortable for you to ask for them, for you to advocate for yourself, to negotiate. If you're in the summit and you're in the tech space, you probably are maybe a little bit more comfortable with them, maybe, not sure. But negotiating them is a very uncomfortable point for a lot of people. I do this on a daily basis. We help clients negotiate stuff, but when it comes to like negotiating a car thing, I leave that to my husband because he's much better at it, like for a car. But I'm obsessed with like helping clients negotiate for themselves and advocate for themselves. It's tough for everybody, but once you start getting with the hang of it, it becomes so much easier. And then also, once we have contracts in place, how do we make sure that they are actually protecting you? So you might have a contract in place, but it might not have what we need it to say. And we've had clients come to us that are like multi-million dollar business owners and they're owed $30,000. And they're like, here's my contract. How do I get my money back? And I'm like, this doesn't say what we need it to say. And then I ask them who drafted this, and they say, we drafted this. And it's like, okay, you maybe should have ran that by a lawyer at some point because now what would have cost you a couple $100, maybe a grand to have this thing reviewed, you're now losing out on $30,000, which is a major bummer. So they are an investment just like any other legal protection, but it can save you a lot of money. Some of the necessary contract terms, let me see, are these out of order? Yeah, these are out of order. Let's do essential, wait, contracts, necessary contracts. They're not out of order. I just wanted to touch on some of the necessary contracts and or terms and or agreements that you might see just interacting as a business owner, or if you have a business, things that you should be looking at potentially having either now, immediately, or pretty soon in the near future. These are just our most common sorts of agreements that business owners need kind of from the get go, or kind of as they're moving through their business journey. Privacy policy is just number one. If you have a website, you have to have a privacy policy, just like point blank. The only time you don't need a privacy policy is if your website's not yet live and you're building and it's not been published yet. The minute it's published, you need a privacy policy. Reason for that is privacy policy is telling your website visitor what you're collecting. So information that you're collecting from them, from names, credit card number, address. If you have an email sign up form, you're collecting their email, their name, maybe even their phone number. If you're allowing purchases on your website, you might be collecting even more information. You're also collecting, even kind of maybe without knowing, you guys are probably a little bit more on top of this being techie, but you're collecting IP addresses, you're collecting all of the fancy internet stuff that you're collecting on a user to your website. So you need a privacy policy the minute you launch your website. There's actual state laws that say you can be penalized if somebody takes action against you for not having a privacy policy. So I would highly recommend getting one in place the minute you have a site that's live. Terms and conditions or terms of use, they have different names, depends on how you want to phrase them, what we're using them for. Highly recommended for your website as well. Not mandatory. There's no real laws that say like you have to have these placed. However, these are the way in which we communicate to our website visitor how they can interact with our website. So it's our like way of creating a contract between us as a business and our website user. Instead of telling them what information we're collecting about them and what we're doing it in our terms, we're usually telling them things like, here's our refund policy, here's our return policy, here's us claiming all of our rights to our intellectual property, here's how you can interact with the site. If you're under a certain age, you shouldn't be using the site. All of the things that you need to, well, should have in place if you have somebody interacting with your site typically go in our terms and conditions. The main kind of flag issue we get here is people wanting to get a refund and like you don't have a refund policy up. So now you're trying to figure out, do I have to give the refund? In most cases, if you don't have something listed and available prior to purchase, you usually have to give them the refund, which sucks if you had an internal no refund policy. So those are really, really important. Um, Definitely take a look and see if you have a website, if you have those up. Sometimes if you had a web developer, designer putting up a site for you, they may have put something in place for you, which they typically shouldn't be doing. We recommend our clients don't do that if they're web designers because it's a like a legal process. They shouldn't be giving legal advice on that. Sometimes you're also going to need disclaimers on your website. ADA requirements also require a lot. You guys probably know this stuff. There's a lot of stuff on your site that needs to be compliant in order to be ADA compliant. So if you have a website, obviously it's important to be able to sell and market yourself, but it's going to create things that you need to have up there too. As a business owner, first kind of contract that you might see come through, or a first kind of indication like, oh, I need a contract for this, is usually an independent contractor agreement if you're hiring a contractor. You might be hiring people and they might actually be employees or they're contractors. There is a distinction. If you're in California, there's a huge distinction. So if you're hiring, that's usually the time where I'm like, you definitely need to go talk to a lawyer to make sure that who you're hiring is actually the role that you think you're hiring for. But typically, if you're a small business owner and you're asking for like part-time, like quick things like a website, or like social media, stuff like that, not like a full-blown hire of somebody that's doing work that you're doing. Typically, it's gonna be a contractor. It is important to have that person on an agreement, not only to say how much they're making, what, their roles are, obviously, but little things like well, it's not so little, but things like confidentiality, NDA, they can't share things that they're reviewing and reading, intellectual property, anything that they create for you, the business should own. If you don't have them sign some sort of agreement and they're creating social media graphics for you, they're creating workbooks for you, they're creating like anything for the business, they own it technically, unless you have an agreement saying that they are transferring ownership to the business. So that's usually another point where people are like, oh my gosh, I need an agreement in place. Contract agreements are just really important. You also have to put on there that they're responsible for like their own insurance, all that fun stuff, because they're contractors. Another agreement that is, it comes up kind of frequently if you don't have an actual agreement that has an NDA or confidentiality provision, is just like a standalone NDA or confidentiality agreement. If you're pitching a business to a friend and you don't want them to like go steal all of your cool ideas or cool things, highly recommend an NDA confidentiality agreement. If you're pitching to like investors, they're a little bit different. It depends on the investors if they're willing to sign that stuff. Sometimes they're willing, sometimes they're not. But if you're pitching your business and things that are internal to your business and you're worried that people might take your ideas or the expression of those ideas, so like things you've written out, like certain processes, you don't want those stolen, I would highly recommend an NDA or confidentiality agreement. You might not be hiring that person that you're pitching to, but you still want them to sign something that says they're not going to share what it is or act on whatever it is they're learning about your business. And then refund return policies, these are kind of like rogue. They're not really an agreement necessarily, but they are policies that go into our terms and conditions on our website, or they go into our client agreements. Those are just things that you should have drafted. They're probably always going to be changing based off of how the business goes, based off of conflicts you encounter, based off of like refunds people ask for. But your refund and return policies definitely need to be very fleshed out. I recommend, like, if you have, competitors in the same space as you, like, go check out what they're saying. See what, they do for a refund if somebody cancels, or, like, see what their shipping policies are. Um, if you want to kind of craft your own, what I usually recommend that our clients do is if they want us to craft, like, an entire terms for their website, I have them tell me, like, "Give me all the stuff that you like from all these other businesses, put them all in a document, and we will configure them to make sure that they are legally applicable and will protect you." But there's nothing wrong with you, like, poking around and researching with your competitors and seeing, like, what their websites say. Um, and then also partnership agreement or operating agreement might come up if you have a business partner. So if you have a business partner and you're either forming a business or like buying into a business, you definitely need to have an agreement in place. This is like number one issue when we have partnerships, is like people didn't have the conversations they need to if the business goes and splits, or if you want to exit because you don't know like the shady stuff that the other business owner is doing. It is very much like getting married to that person. Like, we need to really understand what we're getting into ahead of time, and if there's something that goes wrong, something we don't like anymore, that we have a clean way to exit without it getting like super messy and expensive. Operating agreements are just the document that you should have if you have an LLC. It is essentially just saying how the LLC is to be run. You should have that either if you are a single member or if you have multiple owners or members for your LLC. That can kind of function as your partnership agreement. For corporations, it's not an operating agreement, it's called bylaws. Inside of those contracts or terms or agreements, here's some of the things that I highly recommend. So if you have contracts in place, even if you're like, I've never formed a business and I just work for a company and I want to see like what the most important stuff is, like these are things that you can look at regardless of what type of agreement you're looking at or reviewing or having people sign. These are just the places where we find most of the conflicts happening. Terms of payment, people usually kind of zero in on that because they want to know either how much they're getting paid or how much they're paying out. But what is missing in a lot of these section is what happens if you want to exit early? What happens if you have to cancel an order? What happens if you want to terminate a relationship? What does the payment look like in those situations? Usually not as fleshed out as we need it to be. The more specific, the better. But take a look at these sections because they don't always include information on what happens in these situations. Liability, who's going to be responsible if there's a dispute, if there's a breach of contract, if there's a third party relationship that goes wrong, if there's a product that goes wonky, if there's a relationship that like goes south and like client sues, who's going to be responsible. These are really important sections too. Confidentiality agreements. This is a big one just in general. Any sort of agreement that you're signing, always zero in here. See if you even have the ability to share what's in that agreement. I can't tell you how many times I see people reposting or screenshots of agreements online, and it's like, I know there's a confidentiality provision in there, so you can't be posting that online. You can share that with lawyers. You can typically share those things with like your business partners if it's signed on behalf of the business, but like we can't just go show anybody if there's a confidentiality agreement in a contract. So just be careful if you're either signing something or having somebody sign. We want that in there too, right? Because we don't want people just like sharing stuff about the contract, sharing stuff about our business, especially online. That happens a lot now. Termination. When can you get out of the contract? This is just one that we see just flat out missing all the time. It's a bummer because sometimes the client's like, how do I get out of this contract? And I go and look for this section and it's not there, doesn't exist, or it's not fleshed out enough. And so we have to figure out a way for them to get out of the agreement without breaching the contract, because you can't just walk away from a contract unless the contract says you can just walk away. If you walk away from a contract and you don't have the pathway out that allows you to do that, technically the other side can say you're breaching the contract and then they can sue you, which is a bummer. So anytime you're signing a contract, sending out a contract, take a look at this section. Ideally, there should be a way for you to back out as easily as possible. That's not always the case. Sometimes with like more complex contracts, they can't just always like walk away. They have to provide notice. You have to like provide a certain amount of stuff. But just make sure that's in there and take a look what that says if you're ever signing one too. And also intellectual property. Who owns what intellectual property? Do you own it? Does the business own it? Does the partner retain stuff? If this is really, really important, if you have a business partner or if you're collaborating with somebody for something with the business, anything, good rule of thumb, anything you create, you own. So like your business partner owns stuff that they create, you create what you own. If you guys want the business to own those things, there needs to be something in writing that says that. If you have somebody that's a graphic designer making you like a logo for your business, they need to have you sign something or you need to sign an agreement that says they're handing ownership over. That happens a lot where like people have a family or friend make them a logo and we come to find there's no agreement. And I'm like, you actually don't own that logo. Whoever made it owns the logo. So we need to have you go ask them to sign something. I think that's all for the provisions in there. Essential web policies also. Privacy policy we talked about, terms and conditions, cookie banner is required if you have a website that you're building through like a common, like a Squarespace, WordPress. What are the other ones? Wix. They usually will prompt you to put those things up. So working with a reputable platform is not always going to guarantee that you're legally compliant, but that's why working with a platform like that, they understand that those things are in place. They're not going to be your lawyer, but they will kind of prompt you to be like, hey, you need to put this up. ADA compliance depends on the platform. Some of them will like prompt you to put extra stuff up. Some of them will have partnerships with ADA compliant companies. We have some if you need recommendations, but ADA compliance is kind of, there is no like black and white law that says, here's exactly all the things that you need. The act is so broad that I highly recommend, there's companies that will just help you input like a widget on your website to allow for making your site compliant. If you'd prefer to have a web developer make your site compliant, you can do that, but that becomes really, really expensive for small business owners if you're just starting out. Not impossible, but I would recommend the companies that help you kind of integrate the widget onto your site. Okay, cool. That's all I have. If y'all have any questions, please let me know. I also put it in the chat, but the link to get a free consultation is here, or you can scan this QR code. And I would recommend taking advantage of that, whether you need it now or later. I'm going to send out the link, I think tomorrow, for folks that sign up through this form. and our consults are usually paid. So I would highly recommend taking advantage of that if you need it. And I'm happy to answer any questions if anybody has any questions. Cool. NDA related. How do you balance wanting to share information? I'm just going to read this out loud. How do you balance wanting to share information about your product platform to make sure confidential information is not shared? Do you just keep the confidential content close to your chest? Two ways to look at this. There are some things that you just can't protect, right? The idea to create a product or a platform is not protectable. There's nothing that you can do to like stop somebody from taking that idea. Like there's nothing we can put in place. However, there's ways that we can protect the expressions of that product or platform. So if you're building a product or platform and you have a name for it or logos or branding, we can have branding, logo, etc., through the trademark process. If there's internal things to the product or platform that are eligible for copyright protection, we can also seek protection there. Like coding and stuff is difficult to protect, not impossible, but like how specific coding comes up is potentially eligible. So again, you can protect some of that stuff with copyright registrations. Probably wouldn't, maybe would need patent if it's unique. But I would highly recommend anybody you're pitching to or want to have conversations with, have them sign an NDA just regardless. And then if you're concerned, talk to a lawyer about what is actually protectable of what you're sharing so that you know what you maybe should hold close versus what you can confidently share with them after they've signed an NDA. I hope that helps. Yeah. Just in general, like I usually tell people if they have business ideas, like I know people love to like share stuff with their family, their friends. Um, I just I just tell people to like not share as much unless they have to, unless they like have to have the conversation to pitch to get investors, family and friend rounds, stuff like that. But it's just better. Like usually people that steal business ideas are like people that you know that you're like, oh cool. I had a conversation with you once. Or if you're pitching like um to a bigger company, this happens. We literally had a consult the other day where business was pitching. It's a game. And they were pitching an idea for Hispanic Heritage Month to a larger company, and the company said no. And then weeks later, the company just like did their own thing with the same idea. They didn't take anything that was protectable necessarily, but like it was kind of a bummer seeing that they kind of took that idea and ran with it, which happens. And it's a bummer. But if we can protect what we can ahead of time, if they take our same name, if they take like a way that something is laid out, if they take a specific design, we can then kind of do something about it sometimes. Let me see if this Q&A has Q&A. Yeah, it's a bummer. Yeah. Let's see. Did you guys get the poll? Yeah, it's a bummer. I'm trying to think of anything else that's coming up a lot recently. Subscription payments are another biggie. If your business takes subscription payments or automatic payments, I definitely would talk to a lawyer. I think there's, and like obviously we have consultations for this, but a lot of other lawyers have similar consultations too, where you can just talk to us for like 30 minutes, an hour, and we'll help you strategize. And so you at least know what you should be putting in place or have a plan for like the next year or two, what to put in place. And that is typically like, it's going to be a couple $100s, but it's better, I think, to get that framework in place, have us who, or any other attorney realistically, who is already kind of thinking like that on a daily basis to give you a list of what you should have in place. So at least you kind of can start thinking about it. I think a lot of business owners think that you have to start working with an attorney immediately and we're just going to like suck the life out of your, your bank account. That's not my goal. That's not the goal of a lot of attorneys that I at least know and I work with. We do flat fees. A lot of attorneys that I know do flat fees. So you know exactly what you're paying ahead of time. All of our consultations have like the exact amount that you're paying for them. We will always tell you, like, if it's an additional project or an additional thing, what the pricing is going to look like for that. There's definitely accessible and affordable ways to work with attorneys. It's just you sometimes have to find them. The larger law firms, I know they're like super reputable and great, but they're going to charge you a lot of money. And a lot of times, the solo practitioners like myself have left the larger law firm and then started their own firm. So a lot of us have like a ton of experience and can help you the same way a larger law firm would. We're just going to charge you a lot less. And I find that I have a lot more communication with my clients than some of the other larger law firms. Not always the case, but there's also free programs that will help pair you with law firms specifically that are doing pro bono. So a lot of the larger law firms are required to do pro bono. It's just there's no really good way to like reach out and ask them they're doing pro bono, but there are programs, and I'm totally blanking on the names, but there's programs if you do research that will help pair you with attorneys that are doing specifically pro bono work. Local law schools also reach out to them. They have clinics where they have like 1 to 2 actual attorneys like advising the law students on how to do work. So you're getting stuff for free. It's not by seasoned attorneys that are doing the work, but there is a seasoned attorney kind of managing everybody and making sure that it's getting done properly. That's another way to get potentially some free work, free legal services. There's a lot of ways to get accessible things or information. Uh, Google chat. Let's see. I don't know if this is the chat for. Oh, this is the main chat. Okay. Yeah, if you guys have any other questions, I'm happy to answer. That's our contact info. And again, definitely grab the free consult, whether you need it now or whether you need it later. I think we'll probably close those out by like the end of the year, but you don't have to use it immediately. Yeah, for sure. Thanks for stopping by. I don't actually know what time this one ends. I think 11:30. Let's see. Cool. Oh yeah, you guys can ask questions anonymously too. With the boom of social media and pages popping up and creating content and selling merch, do you feel there are separate rules that apply to them rather than a regular shop? Um, I think I know what you mean by this. Um, so there's no like different rules. There might be like additional things that they have to adhere to just because like if you're creating content on social media, you ideally should be doing original stuff, or else if you're using other people's content, you have to kind of jump through more hoops. Um, if you and I see this a lot with like major accounts that are just like they're creating original content, but they're sharing a lot of other people's content, you have to get permission to do that. And a lot of people don't know that. So they'll create accounts and just like regurgitate other content from other accounts without getting permission. And this happens all the time. This happens to us. I know this happens to a lot of other creators too. And they'll like tag you, but they didn't ask for permission. So if you want to reshare content from other people as part of your own platform and then sell stuff, you definitely need to get permission to do so. Um, if you don't get permission, you can potentially get sued for copyright infringement, which a lot of people don't know. Um, selling merch, uh, the merch stuff depends on, again, how what you're selling. If you're creating, like, original designs on the merch, you don't have to worry about too much. But if you put something on a T-shirt that is the same, like, trademark that's owned by somebody else, they might find you, they might send a cease and desist. So you also need to be diligent as a business owner or a creator if you wanna sell things, sell services, sell products, that whatever you're choosing to sell and put out there, that we're not infringing on other people's intellectual property. So even if you're thinking you're creating like a unique saying or something like that and putting it on a shirt, somebody else might actually own the rights to be able to do that, which sometimes makes a lot of sense, sometimes doesn't if it's like a commonly used thing. Um, So I don't think there's like separate rules. It's just there's different hoops that you have to jump through. Online stuff too is just we find more visible. So if you're selling stuff at a pop up in person, like the likelihood of somebody finding you and trying to sue you for copyright infringement is a lot lower than if you're selling something online. Um, we've had clients that, for example, like love using anything Selena related, but that family is like so aggressive with their IP that it's like you are at risk if you want to sell that stuff. It doesn't mean like somebody's going to come in and make it on your website, but you might get hit with a cease and desist. So you do have to be careful, especially if you're using name, likeness, content from anybody else. Mm. Oh shoot, I should have had captions on for y'all. Sorry about that. I didn't know I could do that. Cool. Any last questions? I think we have 5 minutes left. Double checking all the time. Mm. I can't find it. Scrapping data from websites. Do you see companies going after small apps? Not super frequently. We don't see that problem coming in. But if you have an app, which I'm sure y'all are very techie and probably very involved in app space, there are additional things that you have to comply with when you have an app. So that's another point where I would highly recommend talking to an attorney at some point to give you an idea of what you should be on the lookout for. One of our clients has an app, and we referred her specifically to an attorney that works like only with businesses in the app space, just because those regulations change like almost daily. It's crazy. I would highly recommend, and I can send you recommendations if you need one. But yeah. Also data, if you're using data or information, there's just a lot of like privacy laws that come into play. And if you're using data, selling data, like, there's just a lot of extra stuff on you, which, I mean, there's a lot of regulation. So I would definitely recommend getting, like, at least a breakdown of things you should be looking at. What's the craziest case you've recently come across involving tech and AI? Doesn't have to be yours. I love AI, and I use it personally for a lot of stuff. Um, I think craziest stuff is, I mean, there's attorneys using AI that, like, get in trouble for, like, the AI makes up fake cases, which is nuts. We don't use it for writing anything. We use it for researching, but some attorneys use it for, like, helping them write actual briefs and motions, and then they'll get in trouble and get fined because AI made stuff up. Um, AI is really cool. It's just important to also note that anything AI generated right now, as of how the laws stand, cannot be protected under copyright. So if you want to write a book, if you want to create a workflow, if you want to create anything that's AI generated, the Copyright Office specifically will ask you to disclaim and distinguish anything that's been AI generated, because they don't allow it. It's not human generated. The laws only apply to what humans are creating. So if you put together something with AI and then you add things on top of it, whatever input you've put in, like whatever work you've put in as a human, you can protect, but the AI can't be protected. Um, and there's been cases like going back and forth where the laws are still really heavily relying on, like, no, you have to be a human that created this to obtain protection over something. Um, yeah, AI is AI is cool, but there's a lot of, like, uncharted territory with it as well. And you can't rely on those. That's a place where I would not rely on those platforms to help you either research properly. It's a good starting point to start researching, right? Like, we have a ton of clients that will be like, "Hey, I looked this up on ChatGPT and then I scheduled a consultation with you." Like, I'm not gonna fault anybody for doing that. It's getting them to the right place, but it doesn't always give the right answers, and it's not always gonna help remind you of things that it's not already aware of. So if you have a business and you, like, have this extra part of it that's, like, extremely could be extremely volatile and risky, and you don't tell it about it, it's like the AI is not gonna know unless you tell it, and it might not prompt to ask you for that stuff. If I use AI to edit a transcript of my work, is that considered AI generated? The revisions that it makes potentially are AI generated, yeah. Um The Copyright Office is kinda, like, weird about it. They have on the application, they have you disclaim, and even if you say no, like, we had a client that created really cool, like, game playing cards, and she designed everything on them, didn't use AI, and we put on the application, "No AI," we didn't disclaim anything, and they still, like, the examining attorney came back and was like, "I need you to confirm that there was no AI," because it, like, looked kind of like. So that was interesting. Cool. I think that's all the questions. I think we're done. Only used for edits of grammar, punctuation, outlining more stuff. Yeah, it's okay. It's like okay to use it. It's just if you were to go protect it and apply for protection, you have to disclaim what portions are AI generated. So they might have like uh, most of our clients that have used AI have like used it for really large things. They might have like a de minimis. You don't have to actually tell them for like punctuation. Cool. All right. I think I'm done, y'all. But thank you for coming. Again, if you want the consult, please feel free, fill out the form. You'll get that tomorrow. And I appreciate you being here. And I'm excited to potentially chat with some of you. Have a good rest of your Thursday and enjoy the rest of the summit too.